I tweeted this on June 12, 2020 about Mike Flynn's petition to the Federal Circuit after Judge Sullivan refused to dismiss the charges against him. My conclusion is no writ of mandamus will issue because of the procedural posture, which, as Leslie McAdoo Gordon and others have observed, is not on the nail here. I wish it were otherwise, because the very process Judge Sullivan has unleashed is gravely harmful to due process. It's also a frank separation of powers violation, and the fact that the judge has the power ultimately to follow his obligation under Fokker and Rule 48 to enter the dismissal is not sufficient grounds for denying the writ. Sullivan's solicitation of Gleason's submission here was in and of itself a gross intrusion of the judiciary into the prosecutorial function. As Judge Rao incisively noted in her questioning, who is Gleason's client? The public interest? No. The Constitution does not work that way. Every minute General Flynn remains a defendant in a criminal prosecution, which the prosecutor itself has admitted should not proceed, constitutes a minute of irreparable constitutional harm being inflicted on him. And every minute Judge Sullivan is allowed to arrogate prosecutorial authority to the judiciary, or even the power of inquiry over prosecutorial decision-making, absent prima facie proof of record that raises a plausible inference of misconduct, is an even worse tragedy. Having said this, I could be wrong, and I hope I am. I always urge people to avoid predicting appellate outcomes from the course of oral arguments. Even experienced appellate practitioners have known to misread a panel's inclinations based on its questions. Suppose I'm mainly pushing back against my own inclination toward optimism. I thought the granting of a hearing for the mandamus was significant, and the precedent of Fokker so clear that the time had finally come for someone to put a stop to Judge Sullivan's circus. Well, of course it has. But that doesn't mean they will. A friend just DM'd an agreement. I think the court will hold mandamus in abeyance until after the July hearing. My response, yes, that's the easy way out. And appellate courts usually take the easy way out. I added, I just had that in one of the circuits in which we begged them to reverse a very simple legal error instead of remanding to the lower court with instructions. They declined to make an obvious de novo ruling, even though they agreed with us on the legal rule, and instead only remanded. So the district judge, on remand, just gave the circuit the bird. And we're right back to having to file a fresh appeal of the final order from the trial court at considerable cost and delay to the client, which could easily have been avoided. Circuit court judges are so allergic to anything looking like an interlocutory ruling or criticism of a colleague on the district court bench that the human and financial interests of regular people and businesses seem never to be taken into consideration. This inclination also has important indirect effects that are very harmful to the rule of law and individual rights, as opposed to the perquisites of the state. In the Flynn example, we've heard no concern over the effect of allowing the Sullivan-Gleason hearings to continue on General Flynn, the wrongfully accused defendant, much less future criminal defendants. If mandamus is refused under a wait-and-see rationale, any judge who doesn't like the looks of a defendant, or of his lawyer, or of his social media, or of his political donations, or what John Gleason thinks of him as a person, can open an inquiry into the prosecutor's motivations. In the civil appeal I just described above, the district court established that it will do what it wants to do without any fear of accountability, and there will be no just resolution until and unless the issue is framed just so for review, which the trial judge controls. Similarly, in Mattal versus Tam, when we prevailed in the Federal Circuit on bank and the USPTO Trial, Trademark, and Appeal Board was overturned, the matter was remanded to the U.S. Patent and Trademark Office, which was ordered to proceed with the trademark application of Simon Tam consistent with the ruling. The USPTO refused. It simply disregarded the federal court's ruling. When we asked why, it said, well, we might file cert with the Supreme Court. That's not a valid answer, but The Federal Circuit denied our mandamus petition before the Patent and Trademark Office even responded to oppose it. Yeah, we ultimately won the Supreme Court, but the lesson to the USPTO was, we don't consider your disregarding our direct order to be a thing. You're the government after all, and it's cool. A private party would not be so indulged. I think this is a problem for everyone.